So it will continue opening as we were doing. Huh? Yeah, so we are all ready. Somebody is on phone. And I want to talk very, very low tone today. Yeah? I'm addressing you on the subject matter of commercial surrogacy banned in Kenya. Commercial surrogacy banned in Kenya. Now, in 2014, an Australian pedophile commissioned a 21-year-old Thailand woman as a surrogate mother. The young lady delivered 2 children, a girl and a boy. The pedophile stole the girl, exited Thailand, and left with her to Australia, leaving the young woman with the boy who was suffering from Down syndrome. It was later discovered that that man was a pedophile who had been convicted multiple times on his own plea of guilty for defiling girls who are mostly between 3 and 5 years of age. In consequence of that, Australia passed a law in 2015 banning commercial surrogacy and permitting strictly regulated altruistic surrogacy only for her citizens. So when you go to Australia, there is no commercial surrogacy, and surrogacy is only allowed on a voluntary basis for citizens because of that case. When Russia raided Ukraine, between 20,000 and 30,000 children were taken out of Ukraine to Russia by the soldiers. Shockingly, you have not seen anybody coming up as a parent of those children to ask for their whereabouts. This is because these children were born out of commercial surrogacy, because as we all remember, Ukraine is the only country in Europe which has opened its borders to commercial surrogacy and fertility tourism. Children born out of surrogacy, commercial surrogacy, because they don't have parental and legal protection, are normally the victims of organ harvesting, child pornography, pedophilia, and other forms of abuses. It is for this reason that all religions across the world, whether Muslim, Islam, Christianity, advocate universal ban of commercial surrogacy. If you can remember, on January 8, 2024, the late Pope Francis called for a global surrogacy ban, stating, and I quote, "I deem deplorable the practice of so-called surrogate motherhood, which represents a grave violation of the dignity of the woman and the child, based on the exploitation of situations of the mother's material needs." In October 2025, the United Nations Special Rapporteur called for the global abolition of surrogacy. Earlier on in 2025, African states met in Morocco and drafted the Declaration of Casablanca for the abolition of surrogacy, and Kenya was presented. So there is a global move to ban surrogacy across the world. And I'm saying that the bill we were transacting, called the Assisted Reproductive Technology Bill, is surrogacy bill. Those terminologies were just being used to hide the fact that this is about surrogacy. The Assisted Reproductive Technology Bill was proposed by Honorable 𝗰𝗵𝗶𝗹𝗀𝗀 in 2022. The bill had 52 clauses. When transacting the bill in the National Assembly, I made proposals, and 50 out of the 52 clauses were substantively rewritten. I would not call them amendments. We rewrote that bill. And while rewriting this bill, over 30 new clauses were also added as new provisions, which are now in the bill. The bill was transacted and passed by the National Assembly yesterday. And you would remember I sought recommittal of the bill before passage by the National Assembly to clean up a few clauses which were not clear following approved amendments, and to provide for rules of procedure for the said High Court processes. Since recommittal was not allowed by the National Assembly, those provisions I sought to amend further will now be amended in the Senate. I want to say that the bill which was passed by the National Assembly is in substance very good. That bill, as amended, expressly prohibits commercial surrogacy. And so let us make it clear. Commercial surrogacy is now expressly prohibited in the bill in the amended form. And if you look at clause 4 of the bill, it now expressly states commercial surrogacy is prohibited. Number 2, the bill permits only altruistic surrogacy and only for Kenyan couples or women, whether divorced, widowed, or single, who are certified by an assisted reproductive technology expert to be infertile or incapable of natural conception. The point I'm making is that, number 1, you must be a Kenyan, and I'll be emphasizing that later. Number 2, an expert in the field, and we have defined who an expert, a medical expert in the field is, must certify that you are incapable of natural conception, of carrying a child to term and delivering that child. So we rejected amendments which were being proposed by some MPs who are saying they still want to beget children, but they don't want to beget children through natural delivery by themselves. They want to, engage in surrogacy or hire the homes of other people because they have money to deliver for them. That is out. You must be certified to be so. And that is the category of Kenyans we are helping. Number 3, the bill allows altruistic surrogacy only for Kenyan citizens. There is no room allowed for foreigners to undertake surrogacy or assisted reproduction in Kenya. There is no room for fertility tourism in the country. And that is a fundamental essence of the amendments we brought. So that the thinking that, like in the Australian Thailand girl's case, you can come here, have an embryo implanted into some Kenyan woman. When the child is born, you take the child away out of jurisdiction without the protections of the laws of the country. If you are a foreigner, forget about it. There is no room for you. And even if you are a foreigner already resident, we couldn't allow that room in the bill because we don't know what the fate of the child when you leave our jurisdiction could be. The bill permits altruistic surrogacy only for heterosexual Kenyans. The room that the bill in the original draft was creating for homosexuals to create children through surrogacy in Kenya has been shut completely. And I tell you, if you looked at the original bill, look at clause 2 of the bill, how a couple was defined. Any two people in an association, even if not recognized as marriage in Kenya. Which are these people? Under the Kenyan law, marriage is between male and female. So any two people in an association not recognized as marriage in Kenya, obviously, was a provision for homosexuals. When we amended the bill, we changed those definitions. And you can look at that definition together with what was originally in clause 2. And you will confirm the LGBTQ agenda was complete. We we have deleted all that. So it is for heterosexuals, not for homosexuals. And what we are saying is that if in principle you've chosen an infertile relationship, don't come manufacturing children to groom to join you in that relationship. It will not happen. In all cases where the intended parent is not genetically linked to the child, the bill has been amended to require the intended parent to apply to the High Court for parentage rights and parental responsibility over the child. And you remember this one was at the very heart of debate before the House, with the mover saying, people who do not have children are already traumatized. Why should they go to court again? But we were saying, where a couple cannot conceive naturally, and one of them produces the egg, which then is used to create an embryo, even if that child is then born through a surrogate mother, because one of the couples produced the egg or the sperm, that is their child. There is no going to court. But where you take the egg of a girl X with the male cell of a boy Y, and then you create an embryo out of them, and then you have another person now carry the child and deliver, you cannot get that child without going to court, because that child is not genetically connected to you. So in that case, you will follow the normal adoption procedure, save that you are adopting that child from embryo, because life begins at birth. And we've said the court for that purpose is the High Court. And we are saying that so that there can be records. If the child were to leave the jurisdiction, the child were to disappear like those ones of Ukraine we are talking about, anybody can go to court, check the records, and ask what happened to that human person born in Kenya as a Kenyan. The bill as amended affirms that human life begins at conception and institutes the deserved legal protection of human life, the life of the children born through assisted reproductive technology. I want to say even children born out of surrogacy are equal human beings. And the measures and the protections we have over children born through natural conception must be also availed to children born out of surrogacy. And I'm saying that this is a very serious issue. I've told you about the case of the children of Ukraine. Over 30,000 now have disappeared. And you'll hear they were taken from orphanages, they were taken from centers. These were essentially surrogacy centers. You're not hearing anybody talking about them. These are the persons, when people who have taken them out of jurisdiction want organs, their organs will be taken, and there is nobody to shout, asking where they are. And that is why I started by asking, how come you've not heard of any of their mothers or fathers crying about the children? And so as we speak, we don't know whether those children are alive. We don't know their whereabouts. We don't know where their organs have been harvested. And of course, we are in a situation where they have nobody to depend on for their survival on the face of this earth. So I wish to thank the members of Parliament in the National Assembly, and especially the Family Protection Caucus, for their keenness throughout the period the bill has been before the House. And I thank them very heartily for being alert, because even on the 2 occasions the bill was transacted in my absence, they were alert enough to secure that the amendments we had agreed to before the committee were passed without any alteration, even when there were moves to alter them. Of course, I also want to thank the Health Committee, led by the Honorable Dr. 𝗛𝗵𝗶𝗹𝗀𝗀, for being conscious of matters biomedical ethics around the bill, and for agreeing to be persuaded. Let me also thank Honorable 𝗰𝗵𝗶𝗹𝗀𝗀 for bringing this bill at a time we have been in Parliament, and for allowing that when the matter went for harmonization, which was ordered by the Speaker of the National Assembly, where proposals for amendment made sense, she bent in. And that is why, out of the 52 clauses, we rewrote 50 of the clauses beginning with clause 2 to clause 52, and we added over 30 new clauses. The Senate is now seized of the bill. I ask the Senate to expedite its consideration and secure that the pillars and columns we have instituted in the National Assembly to prohibit commercial surrogacy and to protect the children born through assisted reproductive technology in Kenya from the dangers of organ harvesting, pedophilia, and other abuses are not shaken. Yesterday during committee, I had recommended that we look at a few clauses. Some of them included the definition given to mother and father in the past bill. Because in the bill, if you look at the order paper, what was passed was to define mother as a female intended parent. I mean, mother is a female parent, not a female intended parent. If you look at the definition of parent even in the Children's Act, which we adopted also in the bill, the father is defined as a male intended parent. So confusions in terminologies. I also sought recommittal so that where there is no genetic link between the intended parent and the child, when they go to court, we clarify that procedure. And the provision I intended to bring was to say that the Chief Justice will make rules to guide that process. Of course, that one was also not dealt with. Amendments such as that are now before the Senate, and I know we will be asking senators of the same mind to propose those amendments. I will ask the Senate to not only expedite the consideration of the bill, but also agree to those amendments which make sense. But I want to beg our senators that we have fought very hard to have the bill redrawn to this acceptable form. We will not agree to anything that reverses those pillars and columns we've instituted for the protection of surrogacy from abuse and for the protection of human persons created through that scientific process. And unluckily, let me caution the Senate that they should remember the bill after the Senate will return to the National Assembly. If any changes will be made so long as we are in that parliament, which will interfere with these fundamentals around the protection of the child and the protection of this process from abuse, we will, of course, again amend them, which will risk sending the bill to mediation where it may be lost. I want to ask that we don't do anything that is unprincipled, that may secure that this law is lost. The law, as is now, is good. So for the people of Kenya, to avoid any confusion, that is the law now proposed by the National Assembly. It is going to the Senate. We hope the Senate transacts it before. It does not disappear like the previous attempts. And our hope will be that when it reverts to the National Assembly, will be still there. And it is a law that will be stepping in for those Kenyans who have been struggling with natural conception, but not a law availing opportunity for people who want to abuse surrogacy or commercial surrogacy for exploitation of children and for children research purposes. I can tell you, we have prohibited even research on human body in the bill, and we deleted several provisions around research, even on embryo, which were initially suggested, for the reason that through surrogacy, somebody would come like from Europe into Kenya, okay? You get an embryo from a girl and a man, a lady and a man in Kenya, and you carry the child away because that is what surrogacy requires. When you deliver, the child is taken before you interact with the child. And so for some researchers who do not want to use guinea pigs, it is these human persons they've been using because those human persons have no protections around them. So I'm very happy those are now explicitly prohibited. And I want to tell Kenyans who have been struggling with infertility or difficulties in carrying pregnancy to term that we now have a pathway for you subject to passage by the Senate. I thank you very much. Yeah, that's why I've said for a man you have to be a couple. Okay? And this is borrowed. Yeah, let me explain to you. Even in the case of adoption, we don't allow a single male person to adopt a child, more so a female child. Okay? Yeah, so you understand the theme around it. If you are a man who is not married, and then you beget a child who is not related to you genetically, you would be grooming a wife. That child is not related to you genetically. Yeah, so for a woman, you know the ability of a woman also to care for a child, isn't it? So there are natural things, which in as much as we are saying gender does not apply, some roles are gendered. Taking care of a child, taking care of a child of any gender, you know how they have been. So essentially, let me tell you, we are catering for a couple. If you are a man, you must be in a marriage. So you are firing blanks, but in marriage. Okay? If you are single, okay, you are in an infertile relationship. So you don't want children. You cannot be given a child. To do what with? Yeah. But if you are a lady, we've said you may be divorced, you may be widowed, or you are single, and you need a child. And let me tell you, in the African culture, surrogacy was a traditional type. I don't know whether you remember how it used to be. Yeah, so surrogacy generally is for women. And I'm telling this to male chauvinists. It's for women. Yeah. If you are firing blanks and you are married, you know what in the African context would be advised and you used to be practiced. And I see you are laughing about it. Yeah, so that is what we call traditional surrogacy. Either your wife, if your wife was in and was in marriage, traditional surrogacy, you remember in the traditional sense, your wife then would bring a relative or a sister you marry and they beget children. But now we are not talking of traditional surrogacy, we're talking of altruistic, which I thought is what you are going to seek explanation for. Yes, the same law with regard to abortion, to adoption under the Children's Act has gone to court multiple times. And the courts have said that law is very constitutional. You remember also there was an attempt earlier in the year to even delete it. And you remember my debate on the floor when they were saying a foreigner, they were saying a single man can adopt a child. Okay, how do you take care of that child? And you know our current law also prohibits that. So it borrows from that continuum of principle and values. Any other question? Thank you very much. Thank you very much. Why don't you close that door?
It's a sensor.
So it will continue opening as you